Well, good morning, everyone. I would say good morning to everyone here in the audience, but I already have said hello to the two people that are here. And certainly thank you to those who are joining us virtually. I think we're still learning. The fallout from COVID is that when given the option, it's much more comfortable to sit at one's desk and to listen to these great speakers that we have here today to help us out with legal malpractice and criminal defense matters and ineffective assistance of counsel and other issues for the criminal defense attorney. So welcome again. I am Matt Beier. I am the Senior Vice President at Wisconsin Lawyers Mutual Insurance Company. You are used to seeing Tom Watson kick off these programs, and I'm pleased to note that Tom is now WILMIC's CEO. He was appointed to that position earlier this year, taking over for Katya Kunska, who retired after many, many years. Tom is here today, and we look forward to many years of his leadership in the future with WILMIC. So it's definitely starting to feel like fall as many of us prepare for our kids heading back to school and the CLE blitz begins. WILMIC will definitely be making the rounds in many venues and many upcoming programs, so please look for future announcements describing where we'll be. This program is one of 2 3-hour hybrid programs that we will be offering, although that seems to be quickly turning into strictly virtual programs, but we offer those for free to our policyholders. The other one will be in December, so stay tuned for that one as well. We also offer several free CLE Friday 1-hour only virtual programs, and we just had one with our Director of Claims, Brian Anderson, where they talked about legal malpractice issues with 2 practitioners, Mike Crooks and Bob Levine. Our next program, though, is a joint effort with Boltman Financial, and that will be on September 20. That will be a virtual seminar on cyber risk and cyber insurance. Many of you may have seen messages from the State Bar and Boltman and WILMIC regarding the cyber protection available, the program that Corrine Boltman put together with the State Bar and HSB to offer cyber protection to Wisconsin lawyers. So we'll be talking about that for sure in detail. So now for today's program, which has been approved, by the way, for 3 CLE ethics credits. We have a terrific slate of speakers, and the title of the program is Ethical and Malpractice Issues for the Criminal Defense Attorney. All of the speakers have informed me that they welcome your questions. As a reminder, you do have in the upper right-hand corner of your screen a tab that says Ask the Speaker. Please feel free to use that and use it freely. Submit your questions, and that'll be your chance to hear from Tom, who is fielding those questions, and will relay those to us for responses from the speakers. The first half of our program will be a panel discussion regarding ineffective assistance of counsel. Attorneys Andrew Martinez to my immediate right and Cole Ruby at the end of the table. And I will discuss the legal standards. Well, they will discuss the legal standards because I don't know them. But ineffective assistance claims, Machner Hearings, and then I will chime in with related ethical concerns and just some of the reasons why we're talking about that issue today. And then in the second half of our program, Attorney Peyton Engel and WILMIC's Director of Claims, Brian Anderson, will be joining the panel, and we'll talk about legal malpractice and criminal defense, and we'll address some of the changes that are happening with the actual innocence rule. So why are we talking about these topics? Well, WILMIC chose to address these topics because we've seen a recent uptick in claims against policyholders with criminal defense practices. This is somewhat new to us. Criminal defense hasn't typically been in our top 5 as far as practice areas generating claims. But then in 2021, it jumped to reach our top 5 in that 10% of all of our claims involved that particular practice area. The good news is that severity remains low. So while the frequency is increasing, they are still relatively defensible, and they don't usually involve any large indemnity payment. In fact, many of the claims that reach WILMIC's office, are in the form of grievances. And the most frequent complaint is a lack of communication in violation of Supreme Court Rule 20:1.4. And as Brian points out in an article in your materials, criminal defense clients complain that they were not kept abreast of their case, they were not involved in the defense, or they didn't have an understanding of pros and cons of entering into a plea deal. So we will, as we go through this program, we will offer some tips on communication. And I think perhaps the first three that are in your materials are the ones that are the most important, because they involve not necessarily the direct communicating, but the direct listening. Listen, don't interrupt, and let the client tell his or her story. But we'll talk more about those as we go through today. And then the other type of claims that we are seeing more of involve ineffective assistance of counsel. So why don't we turn to the real experts for their take on this. And as soon as I pull up their bios, I will offer an introduction of Andy and Cole. 1 second. Okay, Andy, Martinez, both Andy and Cole devote their practice exclusively to criminal defense. Attorney Martinez specializes in defending individuals facing charges of homicide, attempted homicide, domestic abuse, and sex-based crimes involving adults or children. He's an accomplished trial lawyer, having tried cases throughout Wisconsin on charges at all severity levels. He also has an extensive history of negotiating dismissals short of trial. Together with Cole, he is a two-time recipient of the Wisconsin Association of Criminal Defense Lawyers Hansen Award. Those awards are issued for winning a not guilty verdict in trial involving a charge of first-degree intentional homicide, the most serious crime under Wisconsin law. Attorney Martinez is an Arizona native. He went to Northern Arizona University, graduated in 2004 with a Bachelor of Arts in Philosophy. After college, he attended law school at the University of Wisconsin-Madison, where he was a senior managing editor of the Wisconsin Law Review. Attorney Martinez graduated and earned his Juris Doctorate from the UW in 2007. He's a founding partner of Martinez and Ruby, which he started with Cole Ruby in 2008. He has spoken often with WACTL, the Wisconsin Association of Criminal Defense Lawyers, and he's a native Spanish speaker and has represented Spanish-speaking clients throughout his career. Cole Ruby, Attorney Ruby, is universally recognized as one of the leading appellate attorneys in the state of Wisconsin. Cole focuses his practice on litigating appeals following convictions at jury trials. He's successfully litigated post-conviction issues in cases involving drug trafficking, sexual assault, possession of child pornography, arson, and homicide. On several occasions, Attorney Ruby has been able to have convictions overturned and charges dismissed completely following clients being convicted at jury trial while represented by other attorneys. It sounds like we have the right guy to tell us about ineffective assistance of counsel. Lawyers throughout Wisconsin frequently contact Attorney Ruby for guidance in handling matters both at the trial and post-conviction levels. He's repeatedly served as an educational source for other lawyers by presenting on both appellate and trial level issues at the State Public Defender's Annual Conference, as well as conferences sponsored by WACTL. As a Wisconsin native, Attorney Ruby graduated from UW-Madison with a Bachelor of Science degree, and following college, he attended law school at UW-Madison, graduating with a JD in 2007. You guys must have known each other.
Correct.
And they started the practice again in 2008. So with that introduction, let me hand it over to Attorney Martinez and Attorney Ruby, and we'll get going on ineffective assistance.
Thank you. I guess first we'll ask if everybody please hold your applause until the end here for the audience in person. So just as a brief introduction, as Matt just read, yeah, Cole is really the appeals guy, and I think everybody in Wisconsin agrees that he is one of, if not the top criminal appellate attorneys in the state. So he absolutely is the right person to talk to you. I have been Machnered several times, so that's where my expertise comes in. So we'll talk about that a little bit. So yeah, Cole, why don't you start with what the standards are for ineffective assistance?
Sure, and good morning, everybody. The way I think about ineffective assistance of counsel in a criminal case, it's basically starting from the position that the defendant has lost. If it's your client has lost. Either convicted at trial or took a guilty plea and got sentenced and usually got slammed, and they want to challenge that. So there's situations where they claim that the trial attorney committed an error. When it comes to ineffective assistance, the standards are essentially two things: deficient performance and prejudice. Deficient performance is that an error occurred. Prejudice is that the error was significant enough that it may have affected the outcome. And to kind of dig deeper into that a little bit, deficient performance is that the attorney that was representing that defendant committed an error, that it was outside the objectively reasonable standards for an attorney in that position. That takes into account things like whether they've investigated the issue, whether they were fully comprised of the facts, whether they listened to their client, and whether they had a reasonable strategy for what they did. Prejudice is whether the error was reasonably, or whether there's a reasonable probability that but for that error, a different result would have occurred. And that can apply both at trial or at sentencing in a guilty plea situations.
And as I'm looking over our materials right now, I realize we never mentioned it, but obviously the what's underlying all of that is the Sixth Amendment right to counsel. The Constitution guarantees you the right to the effective assistance of counsel. Ineffective assistance of counsel is based on the idea that your lawyer was not that he was imperfect, but that your lawyer, he or she, I should say, was so inadequate that their performance fell below the absolute minimum standards established by the Constitution and subsequent decisions.
It's important to recognize that an ineffective assistance claim is not a malpractice suit. It's not an ethical grievance. It's a claim that the criminal case itself would have been different if not for the error. So it's about the clients rather than the attorney, even though it addresses an attorney's error. So these are supposed to be specific claims highlighting specific errors, things that could have been done differently and why, rather than a personal attack on the lawyer or an attack on the lawyer's general competency.
And I should point out that, like as I mentioned, I have been Machnered 3 times, never successfully, and maybe we'll talk about that a little bit more later, but none of those 3 allegations that I had been ineffective were in any way, were accompanied by any sort of ethical grievance or an OLR report or anything like that. I think, from my perspective, and, maybe Cole could speak more to this, I see a claim of ineffective assistance of counsel as an appellate attorney's, as one of the tools that an appellate attorney has to overcome an outcome or overturn an outcome that the client's not happy with. Certainly there are situations in which an attorney might have been so deficient in the performance that a client does want to seek some sort of OLR grievance or some other sort of restitution or some other sort of claim against the attorney, but that's not part of the requirements for making a successful ineffective assistance of counsel claim, correct?
That's right. Correct, yes.
Right.
So in general, I think it's important to recognize that for an attorney doing criminal defense work, getting an ineffective assistance claim against you, getting Machnered, it's kind of the cost of doing business. It's something that's going to happen to just about everybody. If you're trying cases, if you're fighting cases, again, since criminal defendants lose the vast majority of the time, well, depending on who's representing them, but they lose a lot of their cases, and so it's just something that happens pretty regularly.
Couple of things that I chime in with here. One is, I think to be Machnered, I think that you have just been apprised of a set of facts and circumstances that a reasonably prudent attorney could conclude might lead to a claim.
Sure.
And the reason I bring that up is because that is a reportable set of circumstances or facts under at least WILMIC's policy and certainly many others. So that when you do have a set of facts and circumstances like that, reach out to your carrier. Brian is obviously our direct contact at WILMIC. You can certainly call me too. But the idea is that you don't have coverage unless and until you actually report something. Legal malpractice policies are claims made and reported policies, and so if you find yourself facing or being Machnered, as Andy has described it, that is something that we do want to know about. For a lot of reasons. One, coverage I mentioned, but two, we can also try to jump out in front of it and get you consultation and suggestions and advice from an attorney, and that would fall, at least under WILMIC's policy, that would fall under additional benefits, whereby, although it is not necessarily to the level of a grievance yet, someone could be hired like Cole, or Peyton as grievance counsel to assist and anticipate sort of where the situation is going and help navigate that without, doing more harm than good as the process unfolds.
Yeah, I think Matt makes a good point. I mean, like I've mentioned, the times when I have been Machnered have not resulted in any sort of grievance or OLR or discipline or anything like that. But as I mentioned, it can happen. And it's never a bad idea to make sure that you are making sure that you're protecting yourself to the extent that that's necessary.
And the way I understand it, it doesn't even have to be that a claim has been filed against you or a Machner, an ineffective assistance motion has been filed against you. If you understand that you've made an error or the client believes you've made an error that's likely to result in something, you can still report it and get assistance.
Absolutely. That's how you get coverage, and to avoid any sort of gap or timing issue with the report, important to report it sooner than later. It doesn't take much to make a phone call to your carrier and talk to your claims attorney, and that's certainly something that we're ready, willing, and able to assist with. The other thing you mentioned, Cole, that I did want to echo is the issue of competence, and there is an ethical rule out there that deals with competence, and it's SCR 20:1.1. Lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So it's quite a gray area, but here's what I think it says. I think it says that you don't have to be an expert in an area, but it sure helps. And it helps even more to talk to somebody who is. So if you find yourself as a lawyer facing a first-degree intentional homicide claim and you've never handled one before, I think it's not just good practice, but it's necessary that you make yourself competent either by study, which I think it's probably pretty difficult to do as the client sits in your office on initial consultation, but perhaps more appropriately to network and consult with and associate with somebody like Cole or Andy to assist and or hand over or refer or do whatever you need to do to be able to provide the client with competent representation. So that's my spiel on competency.
Yeah, I mean, you're totally right there. And I mean, my experience, certainly when I was a less experienced attorney and even now, my experience is that the criminal defense bar in Wisconsin is extremely collegial and collaborative. So there's almost never been a time when I have called an attorney, when I was facing a situation I hadn't been in before, and asked questions where I've been turned down. And there's never been a time when someone has called me for that kind of advice or consultation and I've turned them down. So yeah, I mean, and it's never, if you're unsure about something, it might be wise to not take the case. I mean, sometimes you have to make that choice too. In fact, people come into my office all the time asking for one of the things I do not handle is OWIs, drunk drivings. And people call and consult and want to hire me for whatever reason on a drunk driving. And I say, look, if you're charged with a child sexual assault or a homicide, like I'm the person you want to hire on that. Drunk driving, that's not for me. Hire my associate, or let me tell you who else you can hire. But if you're not, and the reason I don't handle OWIs is I just don't want to take my time to become good at them or to know what I'm doing. And if you're not willing to do that, don't take the case, right? There's nothing wrong with saying, I appreciate that you called me, but I don't want to, I'm not the person for you to represent you on this case. And that avoids getting in trouble later on down the line where you didn't take the time to become familiar with the practice area, or, your other cases took all your time and you didn't devote the time to study that you needed to, or whatever it was. It's just easier. And I understand that for a lot of people in practice, it's hard to turn down a client who wants to pay you money. It saves you money in the long run not to have to deal with potential issues that may come up with that. Another thing I want to address is something that Cole said is that this is, when an ineffective assistance of counsel claim is raised, it's when someone has lost. Obviously, I think that's overwhelmingly the case. I want to point out 2 of the times that I have been Machnered or that I have been called ineffective were on cases where my client, at the time that I began to represent them, were facing mandatory lifetime prison sentences for repeated, some form of repeated sexual assault, and where in both cases the clients had, I don't want to say no defense, but very weak defenses. In other words, there was a very high likelihood that they would eventually be sentenced to lifetime in prison without the possibility of release. In both of those cases, I was able to negotiate resolutions where they avoided that outcome, and in one of the cases, the person got probation. Both of those people, in my opinion, won the case in the sense that they avoided what was almost a guaranteed outcome of a lifetime in prison. Both of them then called me ineffective and wanted out of the deals that I got for them. So sometimes, you win in all practical purposes, and you are still called ineffective.
Yeah, there's a very different perspective from your position as the attorney and the work that you've done and the outcome that you've achieved and what was realistic versus what the client expects and the client's perspective on what's a loss to them and what constitutes a mistake, what's an error, what's significant to their case. And I think I want to echo the statement earlier about listening to the client, communicating, understanding what the client wants, what their purpose is. It's a good way to help kind of avoid these claims because, again, as attorneys, we have an idea of how a case should be handled, but it's not our case. It's the defendant's case. It's our client's case, and we have an ethical duty to represent them zealously, and that includes taking into account their desired outcome. Obviously, we do that within the bounds of the law and what we believe is appropriate, but we still have to be very mindful of what the client wants.
The theme that we talk about when we address those issues is managing expectations. And one of the tips that's in the materials is explain clearly what can be achieved and what cannot. And that changes, and it changes based on the perceptions and the understandings of the client. And so, I think one of the tips that Brian is sick of hearing me say is, write an IAY letter, not a CYA letter, because that's not what it's about. But it's hey, remember, this is what I advised you about. That's the IAY. I advised you. Because I think that it does a lot of things. One, if you are facing a claim somewhere down the road, and you have that sort of documentation in your file, well, that's great, because then we don't have to get into what he said or she said or the other person said. We've got it written down and it's been communicated, as clearly as possible by way of a writing to the client. So all of that goes into the general idea I think that you're hitting on, which is manage your client's expectations, communicate with your client, meet your obligations under 1.4, and communicate every step of the way. And to the extent that you can, it has to be realistic. You're busy, but when you can and when it's appropriate, and you've given advice, following that up with an IAY letter is a reasonable suggestion.
Absolutely. And I will say documentation is kind of a big thing for me. I do some trial work as well as appellate work, so I'm dealing with clients kind of at all ends of the spectrum. And I recognize there are times where important things happen in the case and there's not necessarily a motion or something else in my file that's going to tell me exactly what I was thinking at the time or what I told the client at the time. So I will type out little memos to kind of document my reasoning on things in case I think this might be something that's going to pop up in the future. And I do the same thing when I'm evaluating appellate cases. If there is a reason why I believe an issue should be raised or shouldn't be raised, I try to have something in my file that will explain my thought process to me in case I forget, which happens when you're dealing with a high volume of cases and a high volume of material.
as a quick follow-up to that, the rule that often accompanies competence is diligence. And that's 20:1.3, where the ABA comment to that rule is that a lawyer's workload must be controlled so that each matter can be handled competently. So be careful with those files that are your least favorite files. Those are the ones that we can forget either on purpose or accidentally. But doing things that help you remember, setting calendars, your own personal calendars about when I should review the file, when I should file this motion, that motion, when I should have a follow-up conversation with the client. All of those things matter and certainly help manage your workload so that you can meet your ethical obligations under 1.3 and provide a reasonably diligent and prompt representation of the client.
So I think Cole had touched on this. And just so that everyone's clear, for anybody who has not seen what an ineffective assistance of counsel motion looks like, there is a version, or there is a copy of one that Cole has filed, a redacted version of one that Cole has filed in our materials, and there's also a transcript of a Machner hearing that Cole did. And a Machner hearing, and we'll touch on this, a Machner hearing is the hearing that happens after there's an allegation of ineffective assistance of counsel. Where were you and
I guess one thing I want to kind of jump in with when we talk about competence of an attorney and errors that are alleged against you, it's important to acknowledge the fact that mistakes are made, that everybody makes errors as an attorney, that no matter how skilled we are, no matter how well versed in the facts and the law we are, we can still miss things. So an ineffective assistance claim isn't a claim that you made errors throughout necessarily. Sometimes it can be a single mistake that is significant enough to the case that can be prejudicial. So I think that for an attorney who is facing a potential claim or has had a Machner claim filed against you, the natural tendency for attorneys, I think, since we're doing criminal defense, is to be defensive, to think, I did everything I could. It's hard to imagine that I did anything wrong. But I think for these type of claims, since we do miss things and since there can be different approaches, for this, ineffective assistance, again, it's not a personal attack, it's a legal argument. It's an argument that an error may have changed the outcome. So there's a lot of citations in our materials about kind of how to respond to these things and what you have to do and what you don't have to do. When it comes down to it, it's if a claim is being made against you, or if an attorney is kind of contacting you about the possibility of a claim, requesting your file, asking questions about decisions that you made, things you did or didn't do, it's important, I think, to be open and honest about your representation and your reasoning for the things that you did, and just be mindful of the fact that it's possible that you made a mistake, and just cooperate to the extent that you're required to under the ethical rules and the case law.
Yeah, I remember getting the Machner or the IAC claims in the two cases I've talked about where my clients were facing mandatory lifetimes. And, my initial reaction was, what the hell is this? I literally saved this person's life and now they're calling me ineffective, which is extremely frustrating. But, in general, I look at it kind of in this way. Look, there are two possible underlying situations with an ineffective assistance of counsel claim. The first is I was ineffective. And if that's the case, I have an obligation ethically, morally, legally to accept that I was ineffective, to admit that I was ineffective, to play whatever legal and ethical role I have in undoing whatever prejudice I caused to the client. I try my best to be an upstanding and ethical attorney, and so that's part of my responsibility. If I screwed up, I need to do what I can to address or redress my mistake. The other possibility is I didn't make a mistake, The other possibility is that I was not ineffective, right? And in that case, I still have an ethical and moral obligation to candor to the tribunal, for example, or to respond ethically as I'm required to under the law to the Machner claim. And then, if I didn't do anything wrong, I guess the end is I'm vindicated, I guess. But really, what's going on is that a person who is unhappy by the way that he or she has been treated by the criminal justice system is trying to redress whatever complaints they have. I may not like that, but they have the right to do that, and it's not some personal attack on me. And in fact, every time that I have been Machnered in that sense, I've been contacted by the appellate attorney, and they've always said, look, I don't think you really did anything wrong, but I have to make this claim. I think this claim is non-frivolous, so I have to raise it. My client wants me to, etc. It's never personal. It's never made in the context of, you shouldn't be an attorney or you should give this up or something like that. And I think it's the knee-jerk reaction for me is always to take it that way, and then of course you can work through your feelings, I guess. But it's not an ethical or an overall attack on your competency, on your abilities, on even the quality of your work in a particular case. There have been times when Cole has been handling cases, he'll tell me about what the basis for the ineffective assistance of counsel claim is. It's non-frivolous. It may even be successful. But I absolutely think, I could have made that mistake in 1,000 cases, right? Like, it's something that, as it says in our materials, every attorney is going to be ineffective sometime.
Yeah, so maybe we should talk about what you should do and kind of how the rules operate when a claim has been made against you. This is kind of past the point where you've provided the file, where you've answered any questions that have been put to you. The motion has now been filed, and there is an allegation out there that you were ineffective in a particular case. One of the first things that should happen, so the ineffective assistance claims, there would be a Machner hearing. There would have to be a hearing where the trial attorney or the attorney that handled the plea and sentencing would be called to testify about the alleged error and what their reasoning was and what they did or didn't do. The first step before that, though, the court may or may not schedule a hearing, because sometimes these motions can be denied without a hearing. It could just be a written decision from the judge. So there's cases where motions are filed alleging attorneys are ineffective, and they never have to answer for it or testify about it because the issue is just denied without a hearing. But assuming that it goes further than that, and a hearing is going to be scheduled, the attorney that has filed the motion on behalf of the defendant should provide a copy and any supporting materials with the motion that have been filed, so that you get a chance to evaluate and kind of review the claims that have been made. And again, since we're defense attorneys and we are naturally defensive, kind of the response sometimes would want to be, well, now I should be able to defend myself. I should be able to kind of put out there why I did what I did. And there's a case that's cited in our materials where this kind of thing happened, where there was a motion that was filed that was pretty sweeping in its allegations of the errors that the attorney allegedly committed. It's the Thompson case, Olar versus Thompson. And that attorney ultimately requested an opportunity from the circuit court to file a written response to all the allegations that were in the motion, which is pretty unusual for the most part. And I think the ethical rules support this. The attorney that's been, a claim has been made against you, you're still bound by the duty of confidentiality and privilege not to say anything until you actually get to the Machner hearing, and there's a waiver that's placed on the record with the court questioning your former clients about the fact that by making this claim, they're essentially waiving the right to attorney-client privilege with the limited scope of matters raised in the motion. And the defendant has to agree to that in order for you to testify at that hearing. So there's some conflicting authority on whether an attorney can respond to an ineffective assistance of claim outside of a courtroom setting. But the general rule is you should not, file your own written response. You should not talk to the district attorney, because a lot of times when these motions get filed, the prosecutor is now defending against it. So the prosecutor will call you and try to get information that would help defeat the ineffective assistance motion. But ethically, you're bound not to talk to the prosecutor.
That's a really weird situation too, right? Because in an IAC claim situation, it's weird. It's this weird situation where the prosecutor's interests and some of your interests are aligned, right? Because we can't deny, or I think it would be unusual for an attorney not to want to be vindicated and to say, I didn't do anything wrong. I don't think there's anything wrong with that, but you have to understand, even though it is perhaps professionally or emotionally beneficial for you to have a judge say, you were not ineffective. And to that extent, your interests align with the prosecutor, who also doesn't want to have to redo this entire case or whatever. You have to keep in mind your ethical responsibilities. Even though you and the DA are aligned on some level, overall, your duty is still to the client. Even though the client is saying that you screwed him or her over in some way, or you failed him or her in some way, your duty is still to the client.
Yeah, that's absolutely correct. So don't talk to the prosecutor. It's a big no-no. When it comes to other responses, I think Thompson is an important case to be aware of and to talk about, partially because it's just so far outside the norm of what usually happens. The attorney was allowed to file this lengthy written response, essentially throwing his client under the bus, throwing the appellate attorney under the bus, and then it was ultimately an OLR claim was filed, and I believe that the recommendation was that the attorney had absolutely violated ethical rules, and the Wisconsin Supreme Court essentially came back and said, no, under these limited circumstances, it wasn't a violation because of the wide-ranging nature of the claims in the motion. And I think that's something I want to address in a little bit about what the motion should include and what it shouldn't. But because of the wide-ranging nature of the claims, basically attacking everything that the trial attorney did, and then the attorney specifically got approval from the circuit court in order to file that response, that the Wisconsin Supreme Court said that it was acceptable under those circumstances, that it wasn't a violation.
Yeah, but I think it's important to pay attention to the qualifications at issue there, right? In the overwhelming majority of cases, you should not respond in any way other than at the Machner hearing, right? Yeah.
And Thompson's important and helpful because kind of along the way, the Supreme Court analyzes the ethical rules that apply at each step in the process, leading to the point where ultimately it made its decision. The motions for an ineffective assistance claim should be limited and specific. And I guess I can't speak for the work of other attorneys. And when we talk about these not being personal attacks, I very well suppose that there are some attorneys that file these claims where they're more personal attacks. And it sounds like it was kind of closer to that line in the Thompson case. But these motions should be very specific in the allegations that were made. This was the specific piece of evidence that the attorney failed to present, and this is why that was important to the case. Or this is the objection that should have been made and wasn't, and this is why it matters, rather than just a general claim of this attorney didn't do anything for me, this attorney didn't have a strategy. Those, a lot of the times, if there are motions that are that broad, those are the ones that get denied without a hearing because you're not specifically alleging errors and not specifically alleging prejudice.
And the Cole's motion that's in the materials alleges a very specific claim, which is basically that the trial counsel at the trial asserted a defense that just wasn't real, right? It wasn't legally viable. And so the entire motion documents, number one, that the attorney actually made that defense. Number two, why that motion or why that defense just wasn't legally real, right? And so,
and kind of the other part of that was that's deficient performance if you make legally invalid arguments, but you can't show prejudice unless the flip side of that is the defendant could have had a valid defense. So the rest of that motion is talking about this is the defense that could have been raised. Here's the evidence that could have supported that and why legally this was valid. So a good motion will go through all of that.
So it's a 16-page motion that is focused on just that issue. There's no allegation, that in general the attorney here didn't communicate or whatever, right? Cole picked the issue, he identified the issue, and then he focused on the validity of that issue. So, like in Thompson, it's unlikely that you're going to have an IAC claim that basically just says this person has never accomplished anything positive for a client ever. That's very rare. So for that same reason, it's very rare that you should be able to respond or you should have to respond.
And I want to, just kind of point out, we've been talking more about claims where the defense attorney doesn't agree with what's being alleged. There are definitely claims, at least in my experience, and I know some other attorneys, where errors are alleged and the trial attorney that's facing the Machner claim agrees with it. They will cooperate completely. They will provide testimony that essentially supports the claim. Because a lot of the time, the way I think about it is, since I've done trial work too, I wanted this client to win to begin with. I believed in their case. I zealously represented them, and then when we lost or had an outcome that the client was not happy about, if there is a Machner claim raised, I still want that client to win. I still want them to get a new trial or a new sentencing hearing because, I'm invested in their case, and I thought that what happened was unfair. So a lot of attorneys that represented clients who I then have the post-conviction motion or the appeal, they're completely cooperative, and they essentially want to see the clients get that relief. It doesn't mean that they're falling on the sword and admitting errors that they didn't actually do, but it's being honest about things that perhaps they missed or perhaps they just didn't consider at the time for whatever reason.
Yeah, and I think that's the other side of the sort of incentive or alignment with the prosecutor that I was talking about, is that sometimes, as Cole was saying, you're still 100% in the client's corner, and that's completely fine as well. The issue is, as Cole said, you still have a duty of candor to the tribunal. You're still going to be under oath at the hearing. You may be motivated to try to get your client a new trial or a resentencing or whatever it is that's being asked for, but you still have to be honest. In other words, if you have to be honest if you were ineffective, if you made a mistake. You also have to be honest if you were not. So, for example, if a client is alleging failure to communicate, as Matt has been talking about, but you have billing records that say, actually, I wrote 40 letters and I went and saw him in the jail 60 times or whatever it is. If you're asked about that, you can't be dishonest about it. I mean, that's true for everything that we do as lawyers. We're not allowed to be dishonest. We shouldn't be dishonest. And one of the things I would say in response, or in that topic, is a couple years ago I gave a ethics presentation. The topic was something along the lines of ethical or good representation is ethical representation. The point being, if you're lying on behalf of your client at your Machner hearing, you are undoing your own credibility, not just generally, but in that case as well. And you may be harming the client's interests by being dishonest. Not that anybody would be, but that's something that people think about. I've certainly heard attorneys say, yeah, I want my client to call me ineffective so you can do this over again or whatever it is. So you have to be mindful of that as well.
And the flip side of that, candor to the tribunal, is you don't lie to the court to protect yourself either.
Right.
I've definitely had attorneys who testify at the hearing and suddenly they didn't do something at the trial and they had a strategy that does not make any sense to me or is completely contradicted by everything I've discussed with this attorney or everything I've seen from this attorney's file, where they're just completely throwing the client under the bus to protect themselves. And that's absolutely unethical as well. So it's important, these hearings, when you get called ineffective, when you are put on the stand to testify, it's about whether you committed an error, but it's not about you ultimately. You don't decide whether you were ineffective or not. You can only testify about the facts, and the judge will determine what the outcome of that claim was. So you stick to the facts and you stick to the truth.
One of the things about that is, I as I've mentioned, I've been called ineffective 3 times. Colleagues of ours that we know to be fantastic attorneys have been called ineffective, sometimes successfully. And in our eyes, and certainly in the eyes of our colleagues, I don't think that is a cause for shame or for some sort of professional doubt in a person's mind. But certainly going to a courtroom and not being honest, those are the attorneys that in our office, at least, we actively recommend people not hire, for example, or we roll our eyes when we hear their names, that kind of thing. Being called ineffective is something that happens or will happen to all of us. It's not a big deal. Being dishonest is a huge deal, and that's something that we all need to make sure we don't do. That's the career ruiner, as far as I'm concerned, not being called ineffective.
There's a lot to unpack with everything that you guys just said. Facing a Machner hearing or facing just a claim of ineffective assistance. And I want to reiterate, I think, the importance of reaching out to your carrier, because those are situations where we can help put you in touch with people who have been there before. And if not your carrier, then exercise your network. Work within your professional associations, whether it's WACTL or other groups. Reach out to those who have been there before to get the advice that they're all sharing now. But I think it's important to recognize that Thompson raises a whole slew of issues, and confidentiality alone can present a pretty sticky web to try to navigate, and to know what you can and can't say and when you can say it and whether or not there's a waiver in place to be able to. If a lawyer who is relatively less seasoned facing that for the first time, that can be particularly daunting. So again, WILMIC's policy and presumably other policies, offer that sort of benefit to help navigate that sticky web and try to figure out how to do that by way of an additional benefits endorsement. That's what we have, and that allows us to hire counsel, not against your deductible, not against your limits. It's just its own separate benefit. But it does give you the benefit of the knowledge of those who have been there before to help you navigate that tough situation.
I think that's what we have. If anybody has questions, we're open to them, obviously. Now you can respond.
Well, we do need to keep going. We do need to satisfy our you mentioned, communication is obviously a big issue, and we can cover a lot of ground in communication. It appears that we do have a question from a virtual member, or maybe from Mr. Watson himself. Go ahead, Tom.
It's from a member watching online. The question is, not sure when to ask this question, so I'll throw it out now. Do you believe that we who practice criminal defense have an ethical obligation to join an association such as WACTL?
I don't know about an ethical obligation necessarily. I think it's just good common sense. Andy and I have been members for probably over a decade, right. And it's an invaluable resource to have other attorneys that you can ask questions to, especially when you're younger and you're learning. But we should always be learning. There's always tips that we can find from other attorneys. So WACTL is a great resource, not just for they have conferences where there are presentations just like this. They have a listserv where you can just submit questions, and any attorney that's a member around the state can answer it. And we contribute regularly to that because it's important, I think, to kind of facilitate a strong defense bar, making sure that other attorneys are aware of the laws that can help them and that can help their clients. It's just a fantastic resource, and I would encourage people to take advantage of it.
Yeah, I agree with that. I don't think there's any ethical obligation to do so, but I agree that it's hugely helpful. Matt talked about taking advantage of your network. There's no better way to form, to build your network or to start a network than getting on WACTL, getting to know the names that pop up all the time, and then going to the conferences and associating those names with faces. If you're thinking about taking a case a kind of case you haven't practiced before, It's a great way to talk to someone, to get in touch with people who know what those cases are like. If you're going to go to a different geographical area, right? You got hired in a county you've never been to before. It's a great way to to find practitioners and talk to them about what practice in that area is like. So I think I don't remember off the top of my head what the cost is, but there's no doubt in my mind that the cost is completely worth the benefits that you get. Matt, one of the things you were talking about, you were just touching on, was communication and documentation. I think that in terms of defending against or being prepared for an IAC claim, that's definitely one of the things that's most important to do. I think that, as we've mentioned, like lack of communication, frustration with your attorney, saying my attorney never called me or didn't come to see me or he didn't come to read the PSI to me or whatever. Those are things that I shouldn't say that are common in IAC claims, but certainly they can form the basis of an IAC claim. And that goes back to your documentation, not only of your time, but of what you've done, like Cole was saying. So, for example, in one of the cases where I was Machnered, I was able to come back immediately and say, well, no, when you say I didn't come and see you, I know I can document that on X, Y, and Z dates I came to see you for an hour, or an hour and a half, or 20 minutes, or whatever it was. When you say I didn't provide you with the discovery, I know that I've provided you with the discovery on X, Y, and Z date in such and such a form. If it's an SBD case, for example, you damn well better be documenting your time contemporaneously so that you can then bill honestly and effectively. And so you can come back and say, oh, yeah, so I know that on August 14th, I was at the Dane County Jail with you for an hour and a half or whatever it is. But if it's a flat fee case, there might be some thinking that, I don't need to as diligently record my time. That's a different question, obviously, that we're not going to get into, billing and all that kind of stuff. But again, having a record of what you're doing, when you're doing it, why you're doing it, how long you were doing it for, those are just sort of easy things to knock down if you're concerned about an AAC claim, if you have significant documentation.
That gets into issues of what you're supposed to do with the file when you're done representing the clients, and kind of how the file impacts these proceedings post-conviction, because the file itself belongs to the client. It's not your file. So once you're done representing the client, they have another attorney, or even if they're representing themselves and they make a request for the file, it is your duty to turn it over. We have some materials in that I think talk about the fact that you're not supposed to charge for it, since, again, it doesn't belong to you. But it is good practice to make sure that you have a copy of the important materials in that file as well, even though you're turning over the original file to the client or the client's successor counsel. And for us, it's scanning things and having a digital copies that we can obtain pretty quickly. But making sure that you still have those materials so that when questions about your performance come up, whether it's from the successor attorney, or whether it's in court at a Machner hearing, or whether it's through an ethical grievance or a malpractice claim, you want to be able to have those materials that you can point to show what you did and why, and the reasoning. It's also extremely important just in terms of if you want to do some sort of preparation for the Machner hearing, if you have to testify and testify truthfully in oath, in court under oath about what you did, I would recommend that you review, not just the motion, but some portions of your file that are relevant to the motion to help you remember what you did. I've had some attorneys where it was very clear that they didn't review anything before they came to court. They just answered questions the best that they could, and a lot of it was, I don't remember, I don't recall. A lot of, the other side, there's some attorneys who want to review everything. They'll review entire transcripts or motions or other documents to prepare. So if you are the subject of a Machner proceeding, if a motion's been filed against you, and you don't have handy access to the materials, you can always request them from the appellate attorney. When I file a motion and I send a copy of the motion to the attorney, I always offer, I have PDFs of the transcripts, I have PDFs of court record documents, so if there's anything about the record you want to review prior to testifying, just let me know and I can send that. And if you're that attorney that's getting Machnered, if you don't have those materials handy, you can request them. It's important to, again, since the issue is being truthful about what happened, it may be very helpful to review those documents.
One of the things, sorry.
No, I can circle back. You go ahead.
One of the things that I wanted to touch on that Cole just mentioned earlier in the presentation, he mentioned that defending against IAC claims, responding to IAC claims, going to Machner hearings, that's all just the part of the cost of doing business as a criminal defense attorney. And number one, I agree with Cole completely about that. My thought is that there are almost certainly people who think, I don't have the time or the money or the capacity to respond to these cases or respond to these claims in a effective way. Cole's right. And feeding into that is the fact that when you're reviewing materials in preparation for a Machner hearing, nobody's paying you for that, and you're not working on something that you can't get paid for. When you're traveling to the court to testify at the Machner hearing, no one's paying you for your mileage or your gas. When you're in court being cross-examined by another defense attorney who's calling you, a failure and a jerk, you're not getting paid for that. And so I get that there.
You can get the very meager statutory subpoena fees and witness fees.
I mean, I guess I'll take my $12 and go home. But and so I understand that there is I think it's natural to feel that there is a number that it's undignified or that it's insulting or that it's beneath you.
It's incredibly inconvenient.
It's totally inconvenient.
And you've got your own caseload and everything else you're working on, and now you have to deal with something that you thought was behind you.
And it costs you money, right? I mean, in our business, if we're not billing, if we're not working for a client, if we're not doing these things, we're not making money. We're not covering our overhead. We're not paying our staff. We're not all these other things. So that's all. I mean, that's a legitimate concern. That's real. But at the same time, I agree with Cole that it is the cost of doing business. If we are in this profession, and I think that it's legitimate to push back on what I'm about to say. It is a privilege to be an attorney. We went to law school and paid who knows how much that was for, right? We pay our bar dues and we pay all, for CLEs, and we travel to continuing conferences and whatever it is. It is a privilege to have our job. And I think it is a privilege to be a criminal defense attorney because I really like it. It is a privilege to stand next to people who are innocent and get them justice. It's also a privilege to make sure that the justice system deals with people appropriately, even when they are guilty. It is totally legitimate to be frustrated, to be angry, to be concerned about your own billing, to be concerned about how much it's going to cost you to make a copy of a file that that is potentially voluminous. Who's going to pay you for your time, and how are you going to put food on your table and cover your expenses and all that other kind of stuff? That's all true. That's all legitimate. But at the end of the day, when we take the job, when we accept the representation of a client, we make a commitment, not only to that client, but to the system generally, I think. And that's important. It's more important, I think, than a lot of these practical concerns, which are legitimate, but we don't have a job. The entire legitimacy of the criminal justice system is at stake if we decide that we are not going to take these kinds of things seriously. As criminal defense attorneys, we always are furious at judges for not taking their duties seriously, for being more interested in maintaining their electability than in following the law. We're always frustrated at prosecutors for doing what is popular rather than what is right, for not arriving at the conclusions that we want them to arrive at. We need to hold up our end of the bargain as criminal defense attorneys, which is to follow the law and which is to respond to subpoenas appropriately, to meet our ethical obligations. In the moment, that may be costly, but if we don't do that, there is no criminal justice system, there is no lawyering, there is no anything, right? Like, everything depends on all of us playing our role, and this is part of our role.
So do you factor that in at the front end? I mean, you just described the headache of the Machner process. Sometimes you may be the third, fourth, fifth attorney. Do you do that? Is that part of your analysis as to whether I even want to take this case on? The risk that I might be a Machner down the road?
Well, I mean, if you're coming into a case and you know that this client has a history, as you said, you're the third, fourth, or fifth attorney, I'm definitely going to factor that in because I'm going to think about, do I have the time to devote to you? You're clearly a client who needs attention. Do I have the time to devote it to you? And I'll be honest, look, sometimes I say no. I can tell that you want more attention than I'm ready to give you. I'm just not the lawyer for you. And that's totally fine. That's no hard feelings. But At the same time, I don't approach the beginning of representation with a Machner hearing in mind, right? Because then I'm just setting myself up and the client up and everybody else. If your client has to trust you. For you to be effective, I don't think this is written down anywhere, but your client has to trust you. I have to be able to have a relationship with my client where he or she trusts me, I trust my client, we can work effectively together in that circumstance. And so I've never come to a consultation, even with a client that appears to be difficult, with a thought process in mind of how do I protect myself from a Machner claim in the future. It's totally legitimate to think about that, and it's totally legitimate to say, I've got some concerns and I just don't want to represent you. I've done that as well. But I think you have to make a decision. Am I comfortable with those concerns? Can I address them? Or am I walking away? I think that would be my advice in a situation like that.
And for me, there's two very different perspectives. There's where I am now, and there's where I was, 8 to 10 years ago. Where I am now is at a point where I very selective about the cases that I take, and I'm very mindful about the type of clients that I'm taking on. And if I know who the trial attorney was, and I get a referral, or if I get contacted by someone, I will send a message to the trial attorney just kind of inquiring generally about the case, hoping to fish out, any information that's, this is a problem person, this whole case is a headache, you don't want this. That's important to know. I mean, those people still need representation, but I am at a point in my career where I can decide not to take on those headaches for myself. Earlier in my career...
Let me just a second. Everybody has a right to effective representation of counsel. Nobody has the right to your representation.
Unless they're paying you.
Well,
Unless they hire you. Earlier in my career, it was taking a lot of public defender appointments and whatever private clients I could get. And I was not in a position where I could just turn people away. And the documentation of thought processes and good communication with clients is incredibly important when you do encounter those people who are on their fifth attorney, or who you can tell right away they're a litigious person, and if you make errors, you're going to be on the other end of it once it's over. So being very meticulous in the work you do, documenting what you do, communicating with the clients, it's extremely important in those circumstances.
Yeah, I think we talk a lot at WILMIC about no being a complete sentence, and it's nice to be at a point in your career when you can exercise that regularly and judiciously. So I want to circle back to the question that came from the audience, and that was regarding whether there's an ethical duty to join WACTL. I think that the ethical duty, yes, there is one that underlies that question, and that is that. And it comes through in the disciplinary proceedings against Innocence, which is cited in your materials. A lawyer is required to obtain the necessary knowledge and skill required for representation. That may require the lawyer to obtain general knowledge about an area of practice, or to associate with a lawyer or a group like WACTL having that knowledge. So I think that the ethical duty is to be competent, and one of the ways that we're suggesting to do that is to associate with people who have been there, and WACTL is certainly one of those organizations that provides those opportunities. How you go about becoming competent is entirely up to you, but there's no specific obligation to join a particular association. We're just suggesting that WACTL is a good one to join, and WILMIC is equally impressed, as Andy and Cole have suggested, that organization does provide resources that almost immediately allow lawyers who aren't in a position to represent in a complete novel area to become so. So I did want to give that bit of an answer to that.
And I would add to that, it's happened more than once in my career, more times than I can count in my career, where I've had a case, I've faced a situation that I hadn't been in before, and immediately was able to recall oh, there was a WACTL post 3 years ago about whatever situation I'm facing, and I can go reference that and at least start it as, or use that as a starting point for research, use that as a starting point for who to contact, that kind of stuff. So, I mean, yeah, I agree with everything. There's no ethical obligation. It is hugely beneficial. And if you're going to do a cost-benefit analysis, I think there's no question that it's worth doing. I think a cost-benefit analysis is also a guiding point with the thing that Cole was just talking about, which is, if you're earlier in your career, if you're mostly doing SPD appointments, those kinds of things, it's really hard to turn down a case, to turn down a paying client, all that kind of stuff. But you still have to think, okay, what is my fee going to be here versus what is there a possibility I'm going to get myself in trouble? Is there a possibility that this is going to take up a bunch of my time in the future with, if there's going to be an OLR complaint or whatever? Yeah, sometimes you don't have a choice. Sometimes you have to think about it, though. So
I don't know what we've got for time, but there was something we talked about regarding no merit reports. If we got time, I can kind of get into that a bit.
Yeah, we've got about 10 minutes. Can I just make one quick comment about billing? I share this often, but when I was in private practice, one of my supervising attorneys shared, and I think this has been shared on many levels in many different areas, but a good lawyer knows what he knows. A great lawyer knows what he doesn't know. And so when Andy was talking about not taking OWI cases, it's because, whether it's because he doesn't want to or he just hasn't had enough experience or whatever it is, he knows he doesn't know that area as well as he does others that he practices in. So keep that in mind. And again, it's one of those benefits of being a member of WACTL is that, when you don't know something, you at least know somebody that you can ask. And then with respect to communication and client intake and billing, I think billing is often overlooked as one of the forms of communication that is most effective with clients. Again, one of my mentors said, be descriptive in your billing. Don't just say conversation with you. Describe what it was about, and what the circumstances were, and offer a little bit more. He said the reason is because you're almost guaranteed that that's the one piece that the client is going to read because it costs them money. So, billing is one of those means of putting a diary in your file about what action you've taken and why it's in there. And even with a flat fee, then the client at least knows what he's getting for the money that he or she has already paid.
And it also just avoids a friction point, right? If you're sending out a letter regularly saying, this is what I've been doing over the course of the past 2 weeks or month or whatever it is, then at least the client, even if you don't have the time or there's not a necessity to call the client and tell him, oh, this is what I'm doing, he's getting a letter that says, oh, okay, great, they're moving forward on something.
Exactly.
Right.
Exactly. They're kept abreast of the case. And then lastly, we talked about what to do with the file. You do have an ethical obligation to retain files, but as has been pointed out a couple times today, it is the client's file. We often get the question, the client has asked for a copy of the file. Do I have to give it to her? Yes, you do. Is the immediate response. But then, the follow-up is, and remember, if there is a claim, your best defense is your file, and it's one of the first things that we're going to ask for. So absolutely retain a copy for yourself. And I think there are too many ways to do that electronically and easily today that it would be appropriate, of course, but necessary maybe to do so.
Now with e-filing, right? Like all of the filings are already they are necessarily available to you electronically. Your own work product almost certainly exists electronically. So now the number of things that you have to independently scan is just lower nowadays.
Very true.
Transcripts are coming to you almost certainly electronically.
Very true. Okay, so we've got about 7 minutes left. Do you want to tackle no merit appeal?
Sure. We talked a little bit about public defender appointments, and there is a feature that's unique to public defender cases that doesn't come up in private cases. And it's not, specifically about ineffective assistance, but that definitely plays a role in it, is no merit reports. If you're taking on a public defender appointed appeal or post-conviction case, there's a specific statutory procedure in Wisconsin that if you determine that the case has, none of the issues, potentially appealable issues have arguable merit, you may have to file what's called a no merit report. There's, once you make that determination that the issues don't have merit, you basically have to give the client three options. It's, I can close the case with no further action and we're basically done here. The second option is you have the right to disagree with me and you can fire me and you won't be able to get another appointed attorney, but you can represent yourself or try to hire somebody. And the third option is a no merit report, which if you're the attorney that's in the position of doing this, it's an incredibly awkward position, because basically you are required to write something that's similar to a brief to the Court of Appeals that identify or kind of explains the facts of the case and then identifies potential appealable issues, but then why those issues don't have merit. So you're in a sense advocating against the person that you're appointed to represent, which is just uncomfortable. And then the client has an opportunity to respond and they say, well, you should have, you could appeal this issue, all these other issues. And so just kind of general advice for when you're dealing with a no merit case. Again, it's being very clear in your communication with the defendant. You need to know the statutes. And offhand, I want to say it's 80930 is the procedure for that. No, 80932. It's one or the other. You have to understand what the rules of it are, and you have to explain it very clearly to the client so they know exactly what they're getting into with a no merit report, because they may get, the no merit report filed and be like, I don't understand what's happening here. You're telling the court that my case is a loser. And if you haven't explained what the process is, they might not realize that that's not the best opportunity for them. They might be better off representing themselves and raising the issues they want. But you need to clearly communicate what you're doing, and you need to clearly document what you're doing, because again, this is an area where they can come back at you and raise ethical grievances against you or malpractice claims. I guess malpractice, that would be more towards trying to get fees back, and if they're appointed, there's not really a fee they can get back from you, but they can still file an OLR claim against you. So again, it's very important to document what you're doing and why, and that you've properly explained everything to the client so they understand it.
And it is 80932. I just looked it up.
Okay.
I think we have a question. Tom.
An online viewer submitted this question. Are the bills also covered by privilege?
Certainly, at least part of them would be, right? Because depending on, you just said, Matt, be descriptive in your billing, and if you're certainly depending on what those descriptions are, there might be product in there that is covered.
Yeah, and I think that's when if the bills have to be produced later, then there's redacted versions that need to be produced.
Yeah.
So I think the short answer is yes. Privilege would apply, and a careful review and redaction would be a good practice.
You're allowed to defend yourself. So if you're being accused of malpractice, that privilege can be waived in the defense of your own actions or conduct. So there may be a waiver of that privilege if someone's questioning you on that.
Yeah, I think that's right. Brian suggested that if you are sued in malpractice, and again, we're talking mostly about things that aren't quite yet malpractice, but could be. But yeah, once it gets to malpractice and we talk about those kinds of elements, those kinds of considerations, then yeah, you absolutely have a right to defend yourself in that civil litigation.
Yep. I don't think that's the case, though. Certainly, if you go to the Machner hearing and your bills are relevant, and the client waives to the extent that then I think the fact that you've been Machnered is not in and of itself a waiver of confidentiality. I don't think for to disclose anything privileged in billing records.
No, I would agree with that. But maybe it would get to the specific claim that's made as the subject of the Machner hearing. So,
which is another reason why it's good to check with counsel, like Matt indicated, so as that you're not walking into a second problem by trying to stop the first one.
Yeah, absolutely. Reach out, use your network, contact your carrier, the carrier should use its network, which we often do. So all of those things are available. Make use of them. Any parting shots, Attorney Ruby?
Just, again, recognize that although a Machner claim brings up allegations of errors that you committed, and it's not necessarily about you, it's still about the client's case. And just follow your ethical obligations that continue to the client even after you no longer represent them, as well as candor to the tribunal and the other obligations that you owe to the justice system.
Yep. Attorney Gonzalez. Any parting shots?
Ouch. It's Attorney Martinez.
Martinez?
I'm sorry.
No, thank you.
All right. Okay, that concludes the first part of our program, and we'll take a 15-minute break, and we'll be back with Brian Anderson and Peyton Engel. Thank you.
Thank you.
Oh my God, what a flood. I'm so sorry. And welcome back, everybody. What a great first half of our program. Thank you, Attorney Cole Ruby and Attorney Andy Martinez. I'll get the name right. I apologize again to you. We are up for our second half of the program. Attorney Peyton Engel has elected to introduce himself, and our Director of Claims, Brian Anderson, will do so as well when it's his turn. But they'll be discussing, as I mentioned at the introduction, legal malpractice and criminal defense, addressing changes in Wisconsin law with a focus on some of the recent events around the actual innocence rule. So I'm going to step away, and we're going to have the full panel here for a riveting discussion on that topic. Peyton, over to you.
Right, so my name is Peyton, and I'm a civil litigator, and you might ask yourself, what is a civil litigator doing here on this panel on criminal defense? It's because sometimes, and increasingly, we see some civil litigation. I do a couple of things in my practice, but one of them is defending lawyers. This is how I come to be friends with WILMIC and Brian. I do some expert witness work in cases where there's digital evidence issues, and that's how I first met Andy Martinez.
How are you doing?
Good. So anyway, what I wanted to talk about today, I should let Brian introduce himself as well.
I thought Peyton was going to introduce me, but no, I'll.
He's just
Brian Anderson. Yeah, and I've been at WILMIC now, getting close to 20 years. So it's been, as I sat here on the initial panel, I thought about when I started in general practice, and one of the areas I did a little bit of work in was criminal defense. And it's kind of scary, and we'll talk about some of these issues as we go along, and we heard some of them already, but where I think sometimes young attorneys like myself, when I started practice, they throw a criminal defense matter to you, and it's a very serious matter in which someone's liberty is at stake, and sometimes you're not necessarily adequately trained or have the resources. So I'm glad to hear some of the tips from the panel about things to do to get advice or help. The WACTO, for example, people like Peyton that I just think one of the things we'll talk about, and I want to stress, is that reach out. The community is helpful, honestly. Lawyers are trying to help each other, trying to help the clients. There are a lot of resources, so never go it alone. If you're insured with us, call. We can help get you to maybe it's nothing more than talking through something with a practitioner. And that's one of the takeaways from a panel like this, is that there are resources available. WILMIC insures a lot of solos, and I mean solo, where it's one attorney, no staff. And when they sometimes call us, the best relief is, I feel so much better having talked to someone. Maybe I'll have them say, who might be a good advice, talk to a guy like Peyton. And it's not such a bad thing after all. The stress is relieved by having disclosed the issue. And so anyway, that's another one of the takeaways. But we're here to help, and this is an interesting topic. Matt, the one last thing I'll say was Matt touched on, for years, I mean, we've been around since 1986. Criminal defense was not even on our top 10. I mean, it wasn't even an area we worried about or thought about in terms of claims, and this is going to be the second year in a row where it's in our top 5. And I'm talking, it's up there with the estate trust and the personal injury and the family law and the real estate areas that you might expect to see claims. We see them, but now criminal defense is in there. And I think Peyton's program will tell you one of the issues that we're seeing and as to why that's now maybe an area that we're going to have claims going forward. So anyway, it's a relevant topic, and it's a topic we wanted to do, but it's nice when the statistics actually back up why we're doing it. And now it is, for the second year in a row, in our top 5.
Right, so I want to kind of get at maybe some of why that's happening. And my game plan is this. I want to talk in a theoretical level about what do we do when, as Cole said, when a mistake happens. What's the right way for the legal system to handle that when an attorney screws something up and a client is harmed? From there, we'll talk about this idea of the actual innocence rule, which has been historically a nice bar to malpractice claims against criminal practitioners. We'll talk about how it grew up in Wisconsin, and that's going to enable us to address the changes that have happened in the last year and a half or so. And then I will try to put on my fortune-telling cap and forecast what I think this means to us. So not just what is the new development, but how might we, as insurers and insureds, be making some adjustments. So as Brian was just saying, the places where you think about attorney malpractice are these ones where there's high value, irreplaceable assets. So things like real estate, large trust and estates cases, and so forth, because that's where it's worth suing, where there's motivation to do that. But claims have historically been rare in criminal law, and that may be changing, and that's where we're headed today. So when you think about what remedies can there be for defendants when an attorney's services fall below whatever the relevant standard of care is, there's kind of 4 basic approaches. One is you could treat it just like civil malpractice. Okay, your attorney screwed up, you can sue him, and tort law gives you a claim for damages. The second one, which is the most common right now, is, okay, you can sue, but only if you didn't do the crime. We're not going to let people who are guilty of what they are accused of sue their criminal defense attorneys. So that's what they call proof of actual innocence. Not just that you shouldn't have been convicted, but that you actually didn't do it. Another standard that some jurisdictions have is to require what they call exoneration, which means you can't file a malpractice suit unless and until your criminal conviction has been overturned. And then the fourth approach would be to require both actual innocence and exoneration, because they're different. You can imagine a situation where someone's conviction gets overturned, but they did do the crime, and vice versa. Like I said, historically, the standard of actual innocence has been the most common and still is today, but we're starting to see that rule get qualified or changed a little bit. So an attorney malpractice claim in general has 4 elements. And this is the sort of classic citation that you'll always see at the start of every brief on attorney malpractice, the Lewandowski case. So you have to have the existence of an attorney-client relationship. In other words, it's very rare for a non-client to be able to bring a malpractice claim.
The only area we see it is a state trust probate where someone's been disinherited. They weren't a client, but they're damaged. But I agree, Peyton.
Right. So, or where an attorney has so badly mismanaged an estate that they've failed to effectuate the intention of the testator, and the testator's dead, so they can't bring the claim, and so the legatee can stand in the shoes of the testator and bring that. So, okay. So first ingredient, attorney-client relationship. Second, you've got acts or omissions by the attorney that constitute negligence. The third is that negligence caused injury to the would-be plaintiff. And then finally, of course, there's the extent and the nature of the injury. So how bad was the harm? And that's a pretty standard recipe for a malpractice case. The actual innocence rule adds a 5th element. It says there's 4 elements, but we have this new one also, which is that the claimant has to actually be innocent of the conduct that they had been charged with. So it's not enough merely to show that the state ought not to have gotten a conviction. There was a very viable suppression motion that didn't get filed. That's not enough. You have to actually not have engaged in the conduct that you were charged with. And we'll see some hair splitting about what that might mean as we get forward. But that's what the actual innocence rule is. And there are some good arguments in favor of it. It's a bright line rule. Bright line rules are easy to administer. It's very efficient at keeping cases out of court. And so just like the rule, you can't vote till you're 18. There's nothing that makes a person who's 18 years and 1 day old that much more wise in the ways of political science than a person whose 18th birthday is tomorrow. But it's a bright line rule, and it's easy to comprehend. There's no waffling about it. It also supports finality in the results that we get, so we don't have to relitigate the facts of criminal matters and get potentially inconsistent results. The actual innocence rule just forecloses that.
Yeah, and it's not so different from the imperi delicto, the unclean hands in the civil non-criminal context. I think it follows nicely there. If you had cheated the IRS and had money that you shouldn't have had, you can't turn around and sue your attorney for not allowing you to commit to continue on with a fraudulent activity. I mean, it's the same kind of idea that you don't want to reward those that are guilty.
Exactly.
And it's a little bit also, Peyton, I think, of the negligent tortfeasor and an intentional tortfeasor, whereby in the civil context, the intentional tortfeasor can't bring a claim against the negligent tortfeasor. So it followed nicely that whole line of reasoning in the civil context, I thought. But you're going to say how this is now cracked a little bit.
Well, yeah, that we'll get to that. But first, let's talk about, so these are the practical arguments in favor of it. But there are, as Brian was alluding to, there are these kind of philosophical arguments as well. And so there are 5 policies that people usually trot out when they're defending the actual innocence rule. And the example that I'm drawing on here is a case called Wiley versus County of San Diego. The citation is in your materials. But that case is influential in Wisconsin because when we adopt the actual innocence rule, we take it just verbatim from Wiley. And so Wiley's rationale, the first one is permitting a convicted criminal to pursue legal malpractice would shock the public conscience, and we just don't like to see it. I think this is probably the other 4 rationales are kind of just spins on this. We don't like the idea of guilty people getting paid just because their attorneys screwed up. So that's policy argument number 1. Number 2 is it shifts the responsibility for the crime away from the convict. So the fact that a guilty defendant got convicted and sentenced, that's their fault. They did the crime, and we shouldn't be moving that, It might be erroneous that they got convicted in the sense that a better attorney might have gotten them a different result, but it's not an injustice in the sense that they're guilty of the crime. Number 3 says, look, tort law, which is what a malpractice claim it sounds in, that only gives you damages for harms to your legally protected interest. And you have no right to, you might be able to get an acquittal if you're guilty, but you have no right to an acquittal. That's and so this isn't a legally protected interest of yours. Your lawsuit is dismissed. Number 4 is the lengthiest one, so you get the smaller font, but it basically says that the idea here is criminal law is a separate ecosystem from civil law, and they don't mix. The fact that some of your rights were offended in a criminal case doesn't give rise to a civil remedy. That's kind of my nutshell summary of that one. And then the final argument is that criminal law affords people protections. You can go get a Machner hearing. You can go get your conviction overturned. You don't have that kind of protection in civil law. You don't have a Fifth Amendment right or a Sixth Amendment right to effective assistance of counsel. You have a lot of protections in the criminal context that you don't in the civil context, and that's another reason why we shouldn't, enhance the repertoire of remedies available to criminal defendants by also giving them access to the civil courts. So, in a nutshell, I think what this means is we just don't like the idea of guilty people getting compensated. And we also, by making this a kind of hard and fast, simple rule, we don't want to have to think about it too often. We want to just, let's just, to hell with them, basically. Okay, so here's a quote from Judge Posner, of course, legendarily articulate, but also no friend of criminal defendants, generally speaking. And he basically is echoing this idea. He says there'd be cases when you've got a defendant who's guilty, and he would nevertheless get damages for the time when he's incarcerated, and that's just intolerable. Because at tort law, the idea is the remedy should make you whole for the harm you've suffered, but the harm you've suffered is just punishment, and so we don't want to make you whole for that. So that's Judge Posner. But there are arguments against the rule. And the argument against it is really pretty simple. Most criminal cases don't even go to trial. Many clients don't profess innocence in the first place. And so if I'm a criminal defendant and I hire Andy to defend me, and I tell him, look, yeah, I did it, but I want you to minimize the consequences, it's not fair if Andy falls down on the job to say, well, I have no remedy. I never claimed to be innocent to begin with. I have a contract where I'm paying Andy for services, and if those aren't rendered, I should have a remedy. And there's a nice case out of Kansas rejecting the idea of the actual innocence rule. It doesn't have a celebrity judge like Judge Posner, but this is basically what it says. If you sue for a conviction that you got because of negligence, you're not profiting from your crime. You're being compensated for a legal injury. It's not like there's not profit any more than you get a profit, by suing the person who smashed into you in a car crash. You're just being made whole for that injury.
I have a question, Peyton, and
yeah.
I'm sorry if we've already covered this. Does the actual innocence rule prevent a defendant from recovering the fee as well, or just from its other damages?
It prevents a malpractice action. If you want to just get your fee back, you might be able to get that via an OLR grievance or some other mechanism. The fee arbitration program. There's avenues for you to pursue fee disgorgement, and maybe you could get a court to order that. But what this is about is preventing malpractice claims, where you're probably seeking more than just the fee.
Right.
But so there's another good case out of Iowa where they also don't like the actual innocence rule, Barker versus Capitosto. And I recommend this one to you just because it has a nice survey of different jurisdictions and their relationship with the actual innocence rule. Who has it, who doesn't. Some places where there are kind of blended approaches. So, for example, Alaska allows convicted criminals to sue their criminal defense attorneys in malpractice, but you can raise actual guilt as an affirmative defense. So it's kind of a mirror image of the actual innocence rule. All right. So what did we do? How do we do in Wisconsin? Where does our actual innocence rule come from? Well, we used to have a sort of implied actual innocence rule in the olden days, and by that I mean 1993. We used to have just this understanding that somebody who's suing ought not to be guilty. And so the seminal case here is Harris versus Bowe. And what it says is that guilt precludes a plaintiff from establishing the causation element of the four-prong malpractice test. In other words, the harm that the defendant suffered is not but for the attorney's negligence. The defendant had a role here. So the theory is that there's the contribution of actually committing the crime is so great as to extinguish the claim against the attorney. And so that's how we did for a long time until we got to Hicks versus Nunnery in 2002. And this is where Wisconsin formally adopts the actual innocence rule and adds that fifth element into the standard for malpractice in the context of criminal representation. As I said before, it follows and adopts Wiley out of California, the case where I ran through those 5 philosophical supports for the actual innocence rule. And what happened was Hicks gets convicted of robbery, burglary, and sexual assault. So it's kind of a crime spree or something. He gets post-conviction relief. His convictions are reversed, and he sues Nunnery. his attorney. Nunnery is found liable, sizable verdict against Nunnery, and Nunnery appeals. And the Court of Appeals says, reverses and says, okay, the actual innocence standard is more than just showing that the criminal jury would have acquitted, right? Hicks has to convince 5/6 of the civil jurors by a preponderance of the evidence that he did not commit the offenses of which he was convicted. And this tips up two things. One, as I said, this is a formal, in bold print, adoption of a rigorous actual innocence standard. But second, it points to another of the kind of wrinkles of malpractice litigation, which is that you get this case within a case. So you've got your sort of outer case, which is the attorney-client relationship, negligence, harm. But now, as to the actual innocence rule, we're going to have a little mini criminal trial inside the civil trial where we try to determine whether Hicks actually committed the crime or not.
Yeah, I don't know, Peyton, if this is a good time to bring this up, but the headache for us at the legal mail desk is that, say that in the Hicks case, it was a plea rather than a trial, and later there's an issue years down the road. The discovery rule applies for legal mail. It may be several years down the road that this person that was convicted, that entered into a plea, first discovers that, wait, my lawyer didn't do certain things, that didn't call certain witnesses, or tell me that they could have done a DNA test, whatever the situation might be. So it gets remanded back for the trial in the first instance that never occurred, when maybe a police officer is retired, the victim's not around any longer. This is a cold case in which the state has no interest any longer because the victim's not interested in the case. So how is that? I mean, this is a problem I foresee, that the lawyer's now facing something that they never could have and never would have been the situation 7 years ago when the case was actually being investigated.
Yeah, and I can't speak from vast personal experience, but in my view, this favors the defendant. That the plaintiff is the one who has the burden of showing that he or she is innocent, and the more memories have faded and exhibits have disappeared, that's going to just get harder and harder to do. Of course, they do get the benefit of the preponderance standard instead of beyond reasonable doubt, but even so, the litigation is going to be an uphill battle, generally speaking. Okay, so Hicks, like I said, was a 2002 case. Everything cruised along nice and sound for a while, and then in 2007 we get the second time the Court of Appeals addresses the question of actual innocence. And there's a guy named Talmadge. He's convicted on 15 counts of child sexual assault. He hires Boyle and pays him $185,000 to file a habeas writ, which seems like a lot to me. Cole, in your experience?
That seems...
I mean, I would take that. Yeah, it's a lot.
That's a lot.
And so Boyle works for 2 years. He never files a writ. He produces a draft. Talmadge doesn't like the draft. He fires Boyle. He hires successor counsel. I don't know what he paid the next guy. And that person files a writ, but by then it's untimely and it gets dismissed. And so he sues Boyle, saying, Boyle, it's your negligence with all this slow and inadequate drafting has harmed me. Boyle wins at summary judgment, and Talmadge appeals. The Court of Appeals just recites Hicks again and says, no, there's no evidence Talmadge could secure a new trial on all 15 convictions. Okay, maybe as to 1 or 2, the convictions are infirm, but he's got concurrent sentences, and it's not going to change anything for him. And the Court of Appeals goes on. In order to prove causation, the convicted criminal must show that but for his former attorney's conduct, he would have been successful in the criminal lawsuit. Success is not merely to have a court grant a motion or order a new trial. Success is a get-out-of-jail-free card. So that seems like a very strong, ironclad reaffirmation of the actual innocence rule. And this, by the way, is the literary device of foreshadowing, because we're going to see this all fall apart in a couple minutes. Okay, so far so good. Plaintiffs have to prove they're actually innocent. They have to actually be innocent of everything, not just some things. But note that both of these cases are Court of Appeals cases. The Supreme Court has yet to say anything on the subject. And so it is that we come in 2020 to Skinzelewski versus Smith. And this gets at an issue that Brian tipped up with his question just a minute ago. So Skinzelewski is some sort of building contractor, and he commits the crime of theft by contractor. When someone hires you to do a remodel, they generally have to pay a bunch of money in advance. And that money is considered to be held in trust and is to be used only on that project. And if you go and spend it on, recreational vehicles or whatever, that's called theft by contractor. It's a crime. So he commits this crime, but he isn't charged until after the statute of limitations has run. Somehow, some enterprising prosecutor brought the case, but they brought it too late. And he's convicted of it. His attorney didn't notice that the statute of limitations has not run. Now, this seems pretty bad to me as malpractice goes. I don't like to use the phrase inexcusable error, but it's pretty darn bad. So he gets post-conviction counsel, and post-conviction counsel gets the conviction overturned. I assume that was a very short, sweet brief. Pretty much a slam dunk for the defense there. So he wants to sue his attorney, Smith. And he says he thinks there should be an exception to the actual innocence rule so that when the conviction or sentence was one that was not authorized by law, you shouldn't have to establish your innocence. That's his thesis before the Supreme Court. Supreme Court says, no, we don't recognize a cause of action for a criminal defendant merely because a more competent attorney would have achieved or could have achieved a better result. So if you concede your guilt, and Skinzelewski admitted, I did misallocate that money. When you concede your guilt, your claim of legal malpractice against your criminal defense attorney is legally barred. And this made those of us who do malpractice work for WILMIC very happy. We thought this was extra protection for our clients. Again, so far so good. You have to be actually innocent. You have to be actually innocent of everything. And there's no exceptions, says Skinzelewski. So the actual innocence rule is on solid legal footing, right? We're safe.
Which is why we didn't see any claims for the first
right.
30 years.
Right.
Possibly.
Mm-hmm. Then we come to Jama I. Jama. And in 2018, he sues his attorney, who had represented him in a criminal proceeding. And his convictions had been overturned, and then he had entered guilty pleas to a couple of counts. But he sues his attorney. His defense files a motion to dismiss that case. The judge says, well, this sure looks like I ought to dismiss it. I'm leaning towards dismissing, but if you want to amend your complaint, you can do that. Jama says, well, I think I will amend my complaint. Thank you very much. And goes and does that. And the amended complaint admits that he's guilty of some of the offenses with which he was charged, but maintains his innocence as to others. Defense renews its motion to dismiss, and the circuit court grants it. Jama appeals. The Court of Appeals decides, well, this seems like a novel issue to us. Can a malpractice complaint survive a motion to dismiss if the plaintiff alleges actual innocence as to some, but not all of the convictions? And they even coined a term for this. They called it split innocence. In a split innocence situation, can a complaint survive a motion to dismiss? And they certify that question to the Supreme Court, and the Supreme Court declines to take the question. One justice abstains. And that seems to indicate that, maybe we're comfortable with the actual innocence rule as it stands. It's good enough